It can be stressful to have to go to court and frustrating when you have to go to court multiple times, and even more so when you have to take off work each time and lose income because of it. You can get charged with perjury if you don't tell the court the truth, but is the court system telling you the truth? That's the subject of tonight's Troubleshooter Investigation. Ben Edens has been a master mechanic for decades, and the workload never lets up.
As you can kind of see now, 1, 2, 3 of these vehicles, which is probably close to about 40 hours worth of work, will be done by about Wednesday. When I'm not here for half the day, none of that stuff's moved.
He wasn't here half the day on June 5th because he had to go to court to answer a texting while driving citation he got while stopped at a light in Oldham County.
Well, I ended up going to court the first time to discuss it. The officer didn't show up. The attorney wasn't versed on what the statute was.
He says they offered him diversion,
which I really wasn't interested in. The law stated that the vehicle had to be in motion, and I was literally stopped at a red light during the time.
He took more time off for the next court appearance, June 19th, and the deputy who cited him wasn't there. The court document listed the reason for the deputy's absence was in-service training.
My employers get pretty upset with me that I keep missing.
Now the owner of the repair shop was overheating, and he boiled over when he saw on Facebook where the deputy really was on June 19th, at the sheriff's golf scramble.
I saw the Facebook picture and someone pointed out as the deputy, and I go, no, there's got to be a mistake because they clearly say that he had in-service training. When I see this, I'm just shocked beyond belief because that's not the way things are supposed to happen, especially in a courtroom.
Certified auto service owner Steve Heggie figures those fruitless court trips cost him over $2,000 and cost Edens between $500 and $1,000.
What happens, technician doesn't get paid, the business doesn't get paid, but more importantly, you, my customer, you're now without a car for another day.
So he started firing off emails to the court. Sheriff's Deputy Michael Meese wasn't present due to in-service training, the court was told. But in fact, Deputy Meese was at the Oldham County Country Club attending the Oldham County Sheriff's Golf Scramble fundraiser. This is a slap in the face for the defendant, his employer, and the court system. I wonder how often this actually happens. We wondered that too and requested any kind of data from the State Administrative Office of the Courts on how often court hearings are postponed or charges dismissed because of officers not showing up. We don't track this data, was the response, and they don't know of any other agency that would have this data. Out more income now, taking off work for his third court date, July 17th, Ben Edens waits while the defendant before him is told his case has to be postponed because that officer has in-service training. Then it's Edens' turn.
He was still looking down and texting.
While the master mechanic regularly uses an owner's manual to repair vehicles, this time he refers to the state law manual to defend himself.
Texting while driving bans indicate that the vehicle must be in motion. As we both indicated, the vehicle was stopped.
After 3 trips to court, costing him as much as $1,000 in income, Ben Edens beats the rap on his $25 ticket.
And the court can't find beyond a reasonable doubt, without any additional evidence, that you were actually receiving or sending that text-based communication while that car was in motion. And for that reason, the court can't find beyond a reasonable doubt that you're guilty of this offense.
But the most important issue of reasonable doubt to Edens and his boss involves the in-service training excuse for the deputy's missed court appearance. So I asked the deputy about it after the hearing.
What they're really mad about was in training means something to them, not a golf scramble.
So, yes, I was at the Kentucky Sheriff's Boys and Girls Ranch Golf Scramble. I wasn't participating or playing. I was helping coordinate it where all the proceeds go to the Kentucky Sheriff's Boys and Girls Ranch. So, yes, that is correct.
Do you think working at a golf scramble should be considered in training?
I can't say what he was told, sir. All I can do is tell you what I told the county attorney, and they agreed to change the court date to today's date. And
so you never told anybody you were in training?
I never did, no, sir.
Did you tell them you were going to a golf scramble?
I did.
And they were okay with that?
Sir, I've answered your question.
His answers didn't cool down Edens' engine.
To me, in-service indicates that the officer has a training or some other form of a job-based duty. When I was sitting in court having to give up a day of work to be here so that he could play golf is pretty frustrating.
Now, the county attorney confirms that Deputy Meese was telling the truth, that he never claimed he was in training. Barry Baxter says, quote, "The error in why he was unavailable is entirely due to a mistake in my office." Baxter says he has spoken with his staff and, quote, "stressed the importance of being correct about the reasons when we request a matter to be rescheduled."